before that, you're like, well, should we count their nonstop flight to Baltimore BWI?
Southwest is the best for like Thanksgiving.
Although compared to getting it from Bell,
Hey, how's it going? Oh, yeah. I think it's podium because I need to be a little like.
Okay, so I'm gonna, this is the clicker.
Oh, okay,
I'll
cool.
just leave it up there.
Okay. I'm after Sean.
Yeah, so I figured, I think he's in there. But do you want, do you want it?
Yeah, that's what I mean. I don't hear.
There's no doubt. Like you should.
Are you gonna use?
You should be a no doubt kind of.
Yeah.
You know, when you go.
We've got a
Turn around my head.
clicker up there.
You
Yeah,
know,
the odds are in your favor, so don't do anything.
just do the right stuff, and you should be. It's a really nice room.
Right.
Great. Well, we're going to go ahead and get started with our next session, which will be taking place until lunch today. So our next session is on emerging trends in patent litigation. And building on the themes discussed earlier this morning, we are now going to discuss and receive testimony from experts on recent trends and developments that relate to patent litigation practice or that have an influence on patent litigation practice. Again, the passage of the America Invents Act in 2011 had introduced measures such as change to joinder rules. In addition, there have been subsequent decisions from the Supreme Court, such as the TC Heartland decision involving venue and many other developments that we will discuss today. So our panel today will consist of two presentations, one from Sean Miller from Stanford, who, along with the two of his colleagues, will present data prepared from the Stanford MP litigation database, and then a second presentation from Professor Colleen Chen of Santa Clara, and then we'll move into questions from the panel, and also, again, we'll invite the audience to submit questions written on cards. So with that, I'd like to go ahead and introduce the panel this morning. First, we have Sean Miller, who is an IP research fellow at Stanford Law School, where he is managing the creation of the Stanford NPE litigation database. Colleen Chen, who is a professor at Santa Clara University School of Law and a fellow of the Stanford Computational Policy Lab. And she also served in the Obama White House as senior advisor for intellectual property and innovation. Next is John Golden, who is the Loomer Family Professor in Law at the University of Texas at Austin School of Law. Then David Schwartz, who is the Stanford Clinton Senior and Zelfa Kilbride Clinton Research Professor of Law at Northwestern University, Pritzker School of Law, where he teaches patent law and intellectual property. And then to his left is Professor Neil Sukatme, who's an associate professor of law at Georgetown University Law Center. So we're going to begin with two presentations, and the first will be from Sean Miller and his students, Rebecca Wires and Joshua Roosevelt. So if you please take the lectern. Thank you.
Thanks, John, so much for having us be part of these hearings. So I'm going to introduce a little more information about my two star research assistants that I'm bringing with me today. Josh Roosevelt and Rebecca Wares, both are future, not too far in the future, patent attorneys who summered at Fish & Richardson's Silicon Valley office last summer, and Rebecca is actually concurrently working on her master's in biomedical engineering, and Josh was a patent examiner for 2 years. So they I'm very lucky to have this caliber of research assistants at Stanford. And for the last 2 years, they've been helping me build this Stanford MP research data set. And what that is it's a 5-year effort started by Mark Lemley and myself to categorize patent plaintiffs in every lawsuit going back to 2000 is either practicing entities or is one of 11 types of non-practicing entities. So the big reason that we started this project is that we're convinced that how patents are used in the system and how they're litigated depends a lot on the type of patent owner, on the business model. And so then if we're going to look and try to figure out how different legal changes have impacted the patent system, we believe that it's going to depend a lot on who the patent owners are. And so for our presentation today, Becca, Josh, and myself, we're using the data from the Stanford MP litigation data set, as well as additional data from Lex Machina, and also we're able to get some PTAB data from Unified Patents. And we're going to give a brief descriptive survey of changes in litigation around recent patent reform. Becca.
Hi, so as Sean alluded to, with our data set, we're able to separate out trends in litigation activity of practicing entities and patent assertion entities, PAEs, and see how they've responded differently to reforms that have happened over the past 8 years. So I'll start by reviewing patent lawsuit filings since 2000 to just give an overview of what's going on, and with a particular eye toward the AIA joinder rule. Josh will present on the relationship between PTAB filings and litigation, and Sean will share how choice of venue and total lawsuit filings have changed in the wake of the TC Heartland decision. So first we'll look at the number of patent lawsuits filed. We'll break that down by PAEs and practicing entities to get some insight into whether reforms were actually effectively targeting PAEs. So here we have total lawsuit filings from 2008 to our 2018 projections from a 20% random sample of our data set. Here we note the stability of practicing entity litigation, that's shown in blue, and relative to the instability and variability in PAE litigation. And so we see an uptick in PAE litigation before the AIA, and that also increased following the AIA joinder rule in 2011 to peak in 2013 to 2015 and a decline since then. And so narrowing in on 2011 and 2012, we see an increase in the number of lawsuits filed, and that's pretty consistent with our expectations about the AIA joinder rule. Of course, we can't totally isolate those effects because of all the changes that happen around the same time, but we would expect that the joinder rule, because it essentially split these large multi-defendant suits into multiple lawsuits, we'd expect an increase in the total number of lawsuits, and we'd expect a bigger effect for PAEs because they were the ones that were bringing these multi-defendant lawsuits in the first place. So that previous graph presents sort of a skewed view of the overall patent litigation activity because the joinder rule itself affected the size of each lawsuit. So here we look at defendant lawsuit pairs. So we look a lawsuit that has 10 defendants here is plotted as 10 separate disputes. And this, we get a good picture of the effect of the joinder rule here. We see again an increase in PAE litigation activity from 2007 to 2011, a major upswing there. But in contrast to the last graph, we don't see continued increases following the AIA and the subsequent reforms. And then, of course, things like macroeconomic trends are going to affect both PAE and practicing entity litigation. So to get a better idea of the effect of reforms that target PAEs, we look at the share of total lawsuits brought by PAEs. And here again, we see a general upward trend from 2007 to 2011. We see that more recently, PAE litigation accounts for pretty much as much of litigation activity as practicing entity litigation, but that upward trend has really leveled off since the AIA. So overall, we've seen since the mid-2000s to 2011 an increase in PAE activity that's leveled off in light of the Joinder rule change and subsequent reforms. But we see that through all of those reforms, practicing entity litigation has been fairly stable. So I'll pass this off to Josh to talk about the PTAB.
Thank you, Becca. So as she just stated, I'm going to talk briefly about the impact that PTAB has had on patent litigation. We'll primarily be looking at whether the availability of post-grant proceedings had an effect on the overall number of patent suits, that is, whether it decreased the number, and also whether the availability of post-grant proceedings disproportionately affected PAEs and pharmaceutical patent owners. We would expect that the availability of post-grant proceeding would reduce the amount of PAE litigation because it is a cost-effective tool to help eliminate low-quality patents. So here this graph shows the total number of lawsuits, the total number of PAE suits, the total number of PTAB petitions, and the total number of PTAB petitions filed against PAEs since the formation of PTAB in 2012. First, focusing on the period between when PTAB was formed and when the Alice decision came out, focusing on the light-colored lines, that light blue line that represents the number of PAE lawsuits remained relatively flat, as the light orange line, which represents the number of PAE PTAB petitions, steadily increased. Interestingly, however, post-Alice, the number of PTAB petitions filed against PAEs stopped increasing, while the number of PAE suits appeared to decrease. Next, we show the percentage of suits filed where a patent has been the subject of a PTAB petition, that is either an IPR or a CBM. And as this graph shows, between 30 and 40% of recent lawsuits involve a PTAB petition, indicating the important role that PTAB now plays in dispute resolution. And here we break down the lawsuits with PTAB challenged patents by industry. Over the entire period, we see that 74% of the lawsuits with PTAB challenged patents are from the high-tech industry. Think of this as computer science, electrical engineering, stuff that comes out of Silicon Valley. 12% are from medical technology, and 14% are from other areas of technology. And although it's not surprising to see a high number of PTAB challenge patents from the high-tech sector, as this graph shows, it's also clear that medical technology is also being challenged. And as this next graph indicates, interestingly, we see that the percentage of ANDA-involved suits and non-ANDA-involved suits with PTAB petition occur at similar rates. Finally, we had time for a cursory look at the impact of PTAB petitions on litigation outcomes. Focusing first on the duration and settlement boxes, we see that lawsuits with PTAB challenged patents last longer and settle less frequently, regardless of whether they're ANDA or non-ANDA patents. Regarding the lower settlement rates, we think that this may be capturing the fact that patents that are both subject of litigation and PTAB petitions are potentially of either higher value or have more validity issues. Additionally, we're going to refrain from interpreting the summary judgment and the trial win rates outcomes since there are various interpretations based on selection effects. More research is needed to determine how PTAB has impacted litigation success. However, we do want to note that the trial win rates are pretty similar both before and after PTAB was formed. So in sum, PTAB post-grant review proceedings post-grant proceedings may have dampened the number of PAE suits. They appear to have been used against ANDA patents and non-ANDA patents in similar rates, and they also appear to increase the duration of suits involving both ANDA and non-ANDA patents. Now I'm going to hand it off to Sean, who will be discussing the impact of venue on patent litigation.
Thanks, Josh and Becca. So the impact of venue, in May 2017, we had this big Supreme Court decision, TC Heartland versus Kraft Foods, and we're going to take a sort of surface level look at the impact of that decision on changes in where patent cases are filed, and also whether or not we think there's indication that there is a large increase or decrease in the number of lawsuits because of the decision. And also, again, using our MPE data set, sort of compare the impact on PAEs versus practicing entities. And here we look, we've already seen this chart showing the relatively stable filings for practicing entity lawsuits versus the highly variable changes in PAE filings with what I've affectionately started to think of as the Alice crater centered around 2014. Here we have TC Heartland pointed out, though, and one thing that I think is interesting is, so we had all these changes between 2011 and 2015, and the last couple of years, it looks like there's actually been an uptick in practicing entity litigation, and also that PAE litigation has started to stabilize a bit. And so perhaps there hasn't been a big change in the number of lawsuits filed due to TC Heartland. However, there's clearly a big change in where suits are filed. So we see here, what I'm looking at is the before and after. So nationally, and then for the busiest patent districts, how many cases were filed the calendar year before TC Heartland and the calendar year after. And we see nearly a 70% decline in filings in the Eastern District of Texas. And then in green shaded, big declines in several of the busy districts that tend to be the ones where lots of companies are located, of course, or in the case of Delaware Incorporated. And we see that Delaware has been it appears to be the big beneficiary of TC Heartland with year-over-year gain of about a third of the Eastern District's loss. And so one other thing, so again, this idea, and I jumped a slide too quickly, but what we saw in the previous slide is that the Eastern District of Texas lost 1,100 cases, or had 1,100 fewer cases the year after TC Heartland as compared to the year before. Nationally, we had 500 fewer cases the year after than the year before. So this might beg the question whether or not we think there are lots of patent plaintiffs that would have filed in the Eastern District of Texas in the absence of TC Heartland, but then are not filing at all because that's no longer an available option with more restrictive venue. And here I'm just pointing out, going back 4 years before TC Heartland, it looks like the year before TC Heartland, Eastern District of Texas had lost about 500, had about 500 fewer cases than the prior year. So it's possible that that a big chunk of the loss in Eastern District of Texas that we observed the year after TC Heartland is due to these other changes like Alice and the availability of PTAB. So now looking at some of the busiest districts, breaking down the changes before and after by practicing entities and non-practicing entities. First of all, at the top, looking at the whole country, and I ask you to focus on the totals in parentheses, that practicing entity litigation has been pretty stable throughout the country, whereas PAE litigation, we saw there's about 25% decrease in litigation the year after TC Heartland. Eastern District of Texas, sort of the reverse, not that there was a lot of practicing entity litigation going on there in the first place, but about 70% less PAE litigation the year after. Delaware and Northern District of California saw about I think an increase in about 3 times as much PAE litigation the year after, with of course Delaware starting from a larger basis. And so this is another part of my current research on venue, looking at the impact of cost and convenience. And one thing I think I'm seeing here is potentially a tendency for some plaintiffs' attorneys that are in PAE-heavy districts, including the Southern District of Florida and Eastern District of Texas, shifting towards neighboring districts post-TC Heartland. And so finally, what we're seeing so far is that we've had a dramatic decrease in filings in the Eastern District of Texas, big changes across the country where patent cases are filed. However, with the biggest winner being Delaware, it's quite possible that TC Heartland has not had that big of an impact on total filings. Thank you so much.
Thank you. And if you join us in thanking both Sean and also students Joshua and Rebecca. Now we'll hear. Thank you. Now we'll hear from Professor Chen.
Thank you. It's an honor to be here today. And I have to say, I remember early in my career attending hearings at UC Berkeley at Haas School in the audience. It could have been the Potofsky hearings, actually, because I went to school back that long ago in 2002. I remember thinking when I was in the audience, what they're doing up there is really cool. I'd like to do that someday. So I'm just warning you, if you're in the audience and you feel the same way, you'll probably be here on the podium in a much shorter time than it took me. But I hope that people enjoy the presentation today. So this is a presentation that I worked on with my students, Nicholas Halkowski, Marvin Mercado, and Priya Voss. And we decided to sort of complement the work of the Stanford group and look at a little further into not only the filings, but what was actually being filed. So the complaints themselves and applications, and really get to this overall question of policymakers are not making changes just to sort of shift around where cases are being filed, but they're trying to increase the quality of the patent system and help it serve the constitutional purpose more fully. So we want to really look at, is quality improving even if quantity is going down? Oops, can I go back one? So just this is a picture of the team, just so you know who are here. And most of these folks are in an artificial intelligence class that I teach. We did some work with AI, which didn't make it into the presentation, but this is just to say that this is an ongoing project, and we're excited that we can just be part of this conversation. So a number of these folks are also machine learning kind of data science people that are not in the class, but it was a fun opportunity, and for those of you who are professors, to do sort of interdisciplinary work together. These kinds of opportunities are very welcome. And a number of these folks have deep experience in prosecution and doing work. We also got a lot of help from open data from the courts and the PTO, but that was supplemented by sources. So there was already a reference to Lex Machina and unified patents. We also were able to work with Harity LLP for access to a tool for analyzing patent traits. Turbo Patents and Ask Alice. Turbo Patents actually is created by a Santa Clara alum as well. They're AI-based systems. We didn't have time to integrate those results, but we'll seek to release those later. So again, my focus, since I was looking our focus, since we were looking particularly at applications, patent applications submitted to the Patent Office, as well as complaints, we were less, I think, focused on things like Joinder or TC Heartland. We were looking at really what's going to impact what's getting filed, the bread and butter of what's being put together by litigators, by prosecutors all over the country as they're writing now their documents and thinking about the changes in the law. So most of these changes are clustered in the 2014 to 2016 period. So even IPR, even though it was introduced earlier, didn't really reach steady state till about 2014. We had the Octane Fitness fee shifting cases in 2014. Alice was decided in 2014. We had Teva, Williamson, and also the Form 18 change happened in 2015. So we thought, well, we can kind of look at this period of time and try to concentrate on what happened before and after it. And as was, I think, sort of maybe the methodology that Sean and his team were working sort of on as well. We were a little more explicit here and wanted to talk about using a differences in differences approach to looking at whether or not the policy changes did bring about causally changes in the environment. Now that analysis is always very challenging and it's hard to do it. So we're going to just show you our results. But the idea is, if you have a child who's sick and you give them some cough medicine, they get better, you might say, well, yeah, the cough medicine made them better. But you can't really be sure unless you actually give their twin, who also has the same illness and is in other ways completely similar to that kid that had the treatment, and you also don't treat that kid, and you see how they do themselves. If they both get better, then it wasn't really the cough syrup that made that first child get better. It's just something else. Maybe they were on their way up, the weather got better, et cetera. So we want to look for control groups that don't have a treatment or that were not targeted by the policy intervention, and to see how they're doing in comparison. And again, Sean's team already referred to that, and we have very similar priors in terms of what ways to control. So we did look at these periods pre and post, before 2014 and then after 2016. And we tried to use our control by thinking about, well, what were the reforms about? They were really about trying to target abusive litigation, so litigation that was sort of based on economies of scale and the cost of defense, by NPs based on software patents in particular. So we looked and tried to then say, well, if those were the target of some of the reforms, how do we then try to develop controls? So we did control by technology, looking at pure software versus a random sample of patents that weren't pure software, and chemistry patents as sort of the most stable in there. We also controlled by plaintiff. Now here we mostly relied on unified patents codings, but those only start in 2015. So we developed another kind of coding, which is high impact patent, which is a patent that's been asserted more than 10 times. And that's just a small cluster of patents, kind of in terms of a proportion of overall patents, but they correlate very highly with PAEs. And you can think again about the economics as being what's important anyway. Even if there is a entity that may be practicing, but then asserting one patent, they're more likely to tap into the cost of defense and the economies that come from economies of scale. So we looked at two types of inputs, or I guess products in our patent system. Complaints, as I mentioned before. And here we wanted to look for quality primarily by looking at, are they more detailed? Are they conveying more information so that the parties can get to a meeting of the minds more quickly? And we had certainly in mind Form 18 change. And so we looked for the presence of claim charts, and we also looked for specific product details like screenshots, accused product descriptions. Now the first one we could look at the entire set of complaints, all of the complaints filed. For the second one we had to do hand coding, so we had a smaller sample. For patent applications, we then also wanted to see, are there more details there? Is there more technical information? Is there more narrowness in what's being applied for? Post-Alice, post-Williamson, et cetera. So we looked at the total words in an application. There could be a lot of boilerplate in that, though. So we wanted to also look at unique words, and so we looked at unique words in Claim 1. Again, not perfect measures. We used a lot of machine-based techniques here, but so it did allow us to get a large volume. Hand coding might result in more fine-grained analysis. So let's just first go to this kind of first assertion about a flight from quantity. And again, Sean's team nicely queued up this and has already reported findings on this already. So I want to just kind of show at a very high level, though, if we take away sort of this idea of patent assertion and NPE, we just look at, again, the economics of who is a high-impact patent asserter, who's asserting a patent that's being litigated many times. We do see that there was a rise and then a fall among those patentees in the red as compared to the non-high-impact patent on the bottom. So those have been down since their peak in about 2012 or so. One thing that wasn't addressed by Sean's presentation, he focused on PAEs, is what about non-PAE NPEs? What about individuals? What about small businesses who are not practicing the patent but are asserting it? How are they doing? I thought it was really important to look at their impact as well, because I don't think that the reforms were as targeted towards individuals or small entities or small businesses, but really focused in the PAEs. So here, again, because the data is from Unified Patents, it doesn't show a really good pre-post. I only have it from 2015 on. But what I think is interesting is to contrast in the red, the PAE share, which has declined, and the orange kind of NPE, non-PAE share. So they both kind of convert, they were both at a similar point in 2015, but they take a similar trajectory downwards, which to me suggests that even if you're a non-PAE NPE, you've also been affected in a way that's different than operating companies. And again, this is data that I think we could probably look at Sean's data to kind of confirm whether or not he sees the same trend, since he has all the granular breakouts, but I think it's an important thing to consider as well. So focusing, though, on the kind of newer findings here about the flight to quality, again, we looked at complaints first, and we tried to look at their length. Again, this was a hand code. I think we actually can do this with machine work, but so it's about 526. So we don't have a great, huge set here. But we did see that there was the change in the law in 2015. At the end of the year, the Form 18 was abolished. And you do see at that point, in coincidence, an increase in the number of pages in complaints. We found this to be the case across all groups we looked at, but again, because our N was only 520 or so, it was hard for us to do a lot of meaningful fine-grained analyses. Now, we were able to do the claim chart analysis across all complaints, and interestingly, we saw that claim charts also became much more common. And that's partly because we had such a low baseline to start with. Almost 1% or less than that was being filed in the 2010 to 2015 period or 2014. And then you start to see an increase, and it's dramatic, right? In 2018, if we look at the complaints filed this year, we see a rate that's closer to 15%. That means that if you are on the receiving end of a lawsuit or you are initiating a lawsuit, you're going to have to you have much more information at the outset of the suit than you used to. So I can't tell you how many people I've talked to who said, I got this complaint and I really have no idea what exactly they're accusing me of and which products are at risk. And that makes it hard for me as a business because I don't know what I can manage, what I might be able to, change the product or negotiate on because I don't know how much of my revenue is exposed by this. So when you have a litigation and a complaint that's filed that's vague and very high level, that can put an entire company at jeopardy unnecessarily because it really implicates, potentially the whole amount of product and revenue stream. So when you have this detail, which we're now seeing in these claim charts where it shows exactly the language of the claim and exactly which elements of a product are being implicated, that provides a lot more certainty to the market about what's actually at stake. So I think this is a good development. We also saw that product details were much more common. So we looked here particularly for screenshots, for claim charts that were embedded inside the complaint, also for actual product descriptions and links to an actual product. So you can see here on the right, for example, this was an AR technology, and they actually put in Pokemon Go and showed exactly what they were talking about and kind of mapped those two things together. So again, going back to the claim chart, the greater increase in claim charts. I wanted to also look briefly at whether there were effects by district. And we saw that there were, again, if you look at all and non-ED texts, or it's probably just most important just to look at non-ED texts and ED texts. At 2015, you see this increase, but then you see a decrease in the Eastern District of Texas with respect to claim charts. And now that could be technology related or something else. So we do need to try to do more work here. Again, this is a complete set, so we can probably do some additional controls here. But it is interesting and notable that ED text kind of takes a different direction with respect to claim chart detail and whether that is needed, or at least the complainants perceive that they need to provide that up front. The same is true, and here we see, a variation with respect to the PAEs and also the non-PAE NPEs. So again, looking at, again, this is a truncated data set, only 2015 on, but if you look at particularly at NPEs, which are in blue, and you look at PAEs, which are in orange, you see that PAEs, they're both filing less than OPCOs in terms of claim charts. They're not filing as many. And again, this could be a technology, there could be a technology explanation. But you do see that non-PAE NPEs are, sort of have continued to have a higher rate than the PAEs. But again, there's not a lot of, there still needs to be some control work. So this is more suggestive, I think, than conclusive of anything. Briefly, let's just talk about patent applications because we are considering Alice and some of the other decisions that took place. Here we could see, again, we were able to look at all the applications filed in these particular art units, which are defined in the appendix. I think the scale here goes from 60 to 90. So if it were actually spread, you would see that there's not a huge change. But you can see that, again, kind of the pre and post idea that there has been a change in pure software patents, that the unique words are being added to a larger degree than they were for pure software. And that happened around the Alice decision. It's about a 14% difference in terms of the initial claims that are submitted. specifications are also becoming longer. And here we looked at software versus non-pure software. So red, pure software, blue is non-pure software. And we looked at chemistry again as the control. And we saw a difference of about 1,000 words. So again, here is where you could see that the software specifications, software prosecutors are working harder. They're writing longer specifications. They're putting in more unique concepts and ideas. And so again, I think I would argue that that is a good thing for the patent system to have more detail in patents. If the problem was low quality patents, flimsy patents, you couldn't tell what they actually covered, now we are seeing more quality there. So in conclusion, what we're seeing then overall in terms of a flight from quantity, that there are fewer scale assertions, right, of the 10+ variety. There are also fewer PAE as well as non-PA/NP assertions. That's the suggestion from the data. We also are seeing more detail in complaints, particularly claim charts, and also more unique words in claims and in the specs. Thank you.
Thank you for that presentation. I think now we'll move on and invite our other panelists to give brief opening remarks of about 5 or 6 minutes. I invite them to both react to the presentations we've seen earlier this hour, as well as to offer their views in particular on if there's anything, any changes in the patent landscape, particularly beginning with the AIA and subsequent Supreme Court decisions that have influenced litigation today. So with that, John, if you would begin, thank you.
Okay, so I think, as you've seen partly through Colleen and Sean and Joshua and Rebecca's presentations, there have been a multiplicity of changes that have tended to kind of raise costs of litigation in certain ways, lower expected rewards from patent assertion, partly through greater opportunities to challenge patents, say through PTAB proceedings. And we might expect these changes to have been particularly important for assertions that are or were likely to be recognized as having been relatively ill-prepared or relatively low quality. And it's reassuring to see that there's some data indicating that when you make legal changes like this, they can actually have some effects. So it's a sort of good story for policymakers that they're not totally helpless in the face of a litigation system that might have some problems. But I do think overall it can be difficult to evaluate where we are and what we've accomplished with regard to the ultimate aims of the patent system, which are looking to promote innovation in the spirit of the title for this hearing, perhaps to sort of promote a healthy, competitive and diverse environment for technological innovation. And you might even say partly to help support the foundations of a healthy democratic culture. So for that, we probably, and it should be sort of a next step, maybe to try to see if we can drill down further to see how these impacts might have differed across different types of actors in the system. To what extent have, say, mid-sized or smaller firms had different experiences or similar experiences in comparison to large firms? What have been the impacts on any individual inventors who remain out there, or university innovators in their licensing programs? So it's always easy to ask for more, but I do think that might be the next step to see to what extent at least we're supporting a kind of diverse environment and ecosystem for innovation, which I tend to think is the healthiest sort of environment for innovation. And of course, ultimately, you'd like to connect this to the kind of fundamental goals of the patent system of promoting technological progress. So with that, I'll turn it over to Dave.
So I appreciate the opportunity to provide my views here today on patent litigation. I wanted to make kind of 2 brief comments about the data and then one more broader institutional comment. First, I want to just second something that Colleen said. Like, it's useful. Like, I thought that the presentation that Sean and Rebecca and Josh did was really interesting and really useful. I think that an enhancement would be to try to separate PAEs into, some other, more finely granular definitions. And so one thing that like I've done in my work is like you could separate and to stop for a minute, Colleen used like NPE and sometimes and I think Sean used PAE. I think sometimes those are a little confusing on what people mean. And so just to be explicit, I would say that you could separate out patents that are enforced by the original owner, which include individual inventors and failed businesses and maybe universities and some other folks on the one hand, and on the other hand, kind of what I call speculators. People are buying patents from others, and I just would be interested in like if there's any differences if we did that. The second data point I want to talk about is the limits of the available data about patent litigation, and that's partially due to selection concerns, but I think it's a little deeper than that. So as we all know, most patent lawsuits settle. Most of the settlements are confidential. And so the win rates on the cases that go to trial are important, and they tell us something, but they might not tell us the whole story. And so I've heard anecdotal stories, not data-driven stories, that accused infringers, like more recently, are less willing to offer meaningful settlement offers out of the belief that the law is very favorable and that they're likely going to win, or that the delay in the case is going to be substantial, such that the plaintiff will eventually give up. And it may be that the underlying negotiating position between the parties has changed such that like the filing rates and the win rates and the summary judgment rates don't tell the full story. And there's very little known about these settlement dollars because they're all confidential. Separately but relatedly, we know very little about pre-litigation activity, demand letters and licensing outside of litigation. I commend the FTC, who did a 6B study a few years ago on PAE activity, looking at these kind of confidential, or at least confidential to the public information. And I raise this really just to encourage others to research this, where I understand it's hard to find data, but I just think we should be cautious in extrapolating too much from the available data that we have. So finally, I want to just note, some of the institutional issues that are going on with patent law. And so we've had a large number of changes to the patent laws. I think that John pointed them out, Colleen pointed them out, the Stanford presentation pointed them out. That includes the AIA, which brought us IPRs, Supreme Court decisions on Alice, fee shifting, venue, willful infringement, Federal Circuit decisions on damages, changes in the rules of civil procedure, as well as PTAB changes, including, notably that the claim construction standard will be changing in the PTAB. Those changes, for the most part, and John noted this, have made it more difficult and more costly to enforce patents, but that's not why I'm mentioning them. I'm mentioning them to highlight all of the different institutional players involved in those changes. So we have Congress, the Supreme Court, the Federal Circuit, the Patent Office. That's a lot of cooks in the kitchen in a small period of time, adding a lot of different ingredients. The patent system is complex, and, maybe to mix metaphors a little bit, it's more like a boat than a car. And I mean, it takes a while for things to turn. And so we have so many changes in such a short amount of time. There's a concern that there's going to be both unexpected and unintended consequences, and that we're not at steady state and you need to let things settle. And so as I think about those different actors that are involved in making these changes, the Federal Circuit has the difficulty of only hearing the cases that the parties bring to it, and really, the parties have very personal reasons for advocating different positions, and it's hard for it to be in like a kind of policy mindset. Congress is different, right? Congress can take testimony from others. The Supreme Court gets amicus briefs, and the Patent Office has the opportunity to take testimony and hear from both patent owners and others affected by the system. And so I just, want to note all of the changes that have happened and think that we want to get to steady state, or like think about things carefully as we're thinking about changes going forward.
Thank you. Neil?
Great, thanks. Thanks for inviting me here. So my background is I'm an economist by training and also a patent attorney. And so as an empiricist, I really want to thank Sean and Mark Lemley and the students at Stanford for the Stanford NPE data set. It's really very useful. It's something that I've used in my research, and I'll talk a little bit about that right now, and I think probably later on I'll sort of go into maybe the details. But I've recently written an empirical analysis of the effect of TC Heartland. And well, first, a few things to note, right? So the question is, what's the long-term impact of TC Heartland going to be? And so what we do in the paper is we use something called an event study methodology around the date of TC Heartland to see how investors responded to the change in patent term rules, right? The change in venue rules. And so what we find is that firms that are incorporated in Delaware in particular were quite happy about this change. And again, I'll go into the details of that. But what I want to sort of cover is venue clearly mattered to patent litigants. It seems like the TC Heartland decision is going to have an enduring impact in terms of where suits are filed, right? They were filed largely in the Eastern District of Texas. We see them moving en masse to the District of Delaware, as Sean pointed out. And I just wanted to sort of highlight and sort of, what was actually going on there in Texas beforehand was this notion of forum selling, right? Texas had sort of had these rules in place, discovery rules, rules that made it difficult to transfer cases, made it less likely to grant summary judgment, which encouraged the filings there in the first place. And the reason why the Eastern District of Texas was able to attract these suits in the first place is because plaintiffs had complete choice of where they could file suit. Really what the defendant's preferences were not really part of the equation at all. And I think a way of thinking about TC Heartland is that it changed the dynamic. Now, where a defendant is incorporated or where it does business is highly relevant in terms of where it can be sued. And so a broader point to take away from TC Heartland, right, and this applies even outside of patent law, is that by giving defendants some choice over where venue occurs, right, essentially allowing both parties to have a say over where lawsuits occur, we can end up with better results. And I say better because, as I'll probably mention later on, my empirical results suggest that firms are quite happy, especially Delaware firms, about this shift to Delaware that's occurring. And to the extent that the interests of firms are opposing to those of patent assertion entities, that suggests that TC Heartland will have an enduring impact on patent assertion entities going forward.
Great. Well, thank you, and I thank all of our panelists for those statements. Now we're going to move into questions. And again, I invite the audience as well to submit any questions that you have on the cards being distributed by my colleagues. So with that, I think Elizabeth will ask the first question.
So both Sean and Neil have talked about TC Heartland, and we've seen some data on the number of lawsuits that have been filed after the decision and where, and Neil has another perspective on it. But I'm wondering if the other panelists have any thoughts on how TC Heartland has influenced litigation behavior, perhaps in a more qualitative way.
I actually have a question, and this would be more, to ask if there's unreported research or this is ongoing, but I think in particular, I'm really interested in the question of the non-PAE NPEs, so thinking about small businesses and individuals, and I'm just wondering if some of these shifts mean that they're not bringing as many suits, or they're also moving to Delaware as asserters. So I just didn't know if you had unreported data or looked into those issues, either of you. I think you have the data, but I don't know if you looked at it yet.
So I'm sorry, what particular kinds of suits are you?
Small entities that aren't PAEs.
Yeah, so, thinking about folks who could bring a suit in, not even in Texas, but in New York, because that's where they're based, instead of having to go to the defendant's home turf in California, which is a lot more of a burden to them. So if you think of a small business which has a patent that they want to assert, that's a lot harder now, potentially, to have to go to the defendant's venue. And I'm just wondering if that is reducing the number of suits by these entities. We saw that those were going down overall, at least as expressed by the unified patents data, and I wondered if TC Heartland was part of that story. Again, in the data that I showed, it didn't look like there was a particular steeper decline or anything, but I just didn't know.
Nothing directly on point. So my TC Heartland project that I'm working on right now is actually not really a TC Heartland project. It's looking at the importance of home court advantage for choice of patent venue. And so ideas of whether or not parties think that that there might be bias towards local parties, and also cost and convenience concerns. And one thing that I'm seeing, so I've broken it down again by PAEs like I did here, which combine both those categories of PAEs that Dave talked about, the ones that are started by the inventors of the patents and those that acquire patents, and then also practicing entities. And the one thing that you're seeing is, so before TC Heartland, this might be a surprise, might not be, but very large percentage of the cases were filed in the plaintiff's home court where their principal office is. And the big change that I've observed so far is after TC Heartland, there's not an increase in filing in a defendant's, where a defendant's principal offices are, but there is of course, a decrease in filings in the plaintiff's home court. But so what they're doing is they're moving to neutral sites, right? So primarily Delaware. And I've thought about that. I think that's an important extension, is to think about, so my results are suggesting that that parties do care about being close to home, and you would expect that smaller entities would probably care more insofar as cost is an issue.
I will comment that when Michael Risch and I did our study before TC Heartland to look at the dynamic impact potentially projected, we did not think that small entities would be hurt that much because they weren't necessarily filing opportunistically in the Eastern District, because that's too far themselves. They were filing closer to home, and so it depends, again, if they're located mostly closer to Delaware or Northern California, then, it depends a lot on the relative position of them to those locations of interest.
There could also, I would just add real quick, there could also be correlations between small entities tending to be from different industries, right? Where it's possible that small entities, typically you're seeing some types of practice entities, well, they tend to sue their neighbors, right? So if you're a machine shop or some sort of, I'm trying to think, like an importer of some good, you're suing another importer of a similar good that also happens to be in LA, right? So maybe then there's not as big of an impact on costs for those smaller entities.
Yeah, I wouldn't expect a huge effect on those entities, because the folks who really were taking advantage of the Eastern District of Texas were the patent assertion entities. And also another important thing to keep in mind here is that TC Heartland, the venue statute has got these two prongs, right? So the Supreme Court interpreted where a corporation resides is no longer where it's subject to personal jurisdiction, right? It's not just you committed an act of infringement. What they said, resides means where you're incorporated. However, you can still be sued any place you commit acts of infringement and if you have a regular and, quote, regular and established place of business, right? So we've seen some litigation since then in the Federal Circuit to try and interpret what that means. But it's important to know that TC Heartland doesn't sort of limit you, if you're a Delaware corporation, to suit in Delaware, but it certainly makes it impossible essentially for you to be sued everywhere unless you have facilities everywhere. And that's what I was sort of referring to earlier, in the sense that now, under the current, the new system, right, both plaintiffs and defendants essentially have some control over where lawsuits can be filed, right? Because defendants, where they decide to actually establish their regular and established places of business and where they're incorporated, those are essentially the choice set from which plaintiffs can pick where they're going to file suit.
I just want to jump in, it's just to sort of reinforce Colleen's question. I guess we're both sort of concerned about this. I think partly part of the concern is these sort of gross statistics may not reflect what might be a relatively small percentage of litigation overall that's filed by, say, these smaller or mid-sized companies, but might be very significant to those companies with their business model. This relates to some work that I did years ago looking at patent infringement injunctions, where it turned out if you looked at who's getting these patent infringement injunctions, they're often these kind of niche companies with technologies that wouldn't be so prominent or high tech, or you wouldn't even think necessarily was so valuable, like a sort of tub for a veterinarian to use for a dog or something. It's being, or there's a coffin design, which I'm not sure that patent should have been issued, but it was very important for this company that apparently sells something like 50% of the coffins in the United States, at least at that time. And so I think this was part of our concern, that the concern that Colleen raised, and was something that I adverted to in my initial remarks, is that you might need to look at things more in a more granular way to get at what might be a kind of middle-stand level of companies for which patents are disproportionately important.
Yeah, just to reiterate, I mean, I guess I have the same reaction Colleen and John have, that it just seems like a fairness issue when it's a small plaintiff suing a large defendant to have to litigate in the defendant's home court. There was also a fairness issue when, large plaintiffs were suing small defendants and they were suing them in the plaintiff's home court. That also seemed to be, a fairness issue.
Great. Well, thank you. I think we'll move on to another subject, which is the PTAB. In our previous panel this morning, we've heard a lot of discussion regarding the implementation of the PTAB, and I would like to ask this panel as well, I guess from a litigation perspective, how has the creation of the new proceedings at the PTAB influenced the litigation practice? Perhaps, Dave, if you could speak to this.
Okay, great. So I want to make 2 points. One has to do with the delays and the kind of effects on small business owners that are patent owners, and then the second has to do with this kind of oncoming post-grant review, PGRs. But before I do that, I just want to say that I do think that a fair and balanced post-grant proceeding to effectively remove invalid patents is both appropriate and necessary, because patent litigation is very expensive. It's expensive for plaintiffs, it's expensive for defendants, and there are practical limits to the thoroughness that the PTO can conduct its initial examination. But one thing to keep in mind is the delay caused by an IPR. And so the Stanford folks had some data that there is a delay in cases that have a patent IPR'd. Makes sense because the process takes time. It generally takes about 18 months from petition to decision, and if you had a Federal Circuit appeal, that might take another year. And there was also some data from, I think Sarab was talking about on the last panel about stays. And so stays are somewhat common, although not guaranteed, in when there's an IPR. Stays and delays in litigation are not neutral. And so the kind of conventional wisdom in civil litigation, it's not a patent litigation issue, is that delays harm the plaintiff, and especially smaller plaintiffs, and benefit larger defendants. And it's especially true where the plaintiff, a smaller plaintiff, needs either the recoveries for some business reason, or in order to obtain financing through alternative litigation financing, or trying to entice an attorney to accept the representation on a contingent fee representation. And so making the litigation substantially slower and riskier, but really slower is enough, it just makes it harder for those smaller patent owners to enforce their rights. And for sure this had an effect, and maybe an intended effect, on the kind of PAEs that are speculators, but it also has a similar effect on smaller businesses that aren't speculators, but they're actually just small businesses. And so I just would balance this against, the concern that speedier resolutions increase the risk that there's settlements in cases that are actually weak or very, very questionable on the merits. And so this is all like a very delicate balance. The second point I want to talk about is on post-grant reviews. And so there aren't very many, there haven't been that many post-grant reviews conducted. Those are limited to patents that were filed under the first-to-file provisions of the America Invent Act. But over time, we expect there's going to be more patents that are eligible for post-grant review, and therefore there will be more post-grant reviews. And we don't know whether in the future those will substitute for the roles that IPR plays today. We could look at trademark oppositions, which is actually, I think, relatively well used, although trademarks has kind of different characteristics where it's easier for companies to identify marks that might be potentially problematic in the future. I don't know if the same would hold true for patents. We could look at European patent oppositions. But the truth is we don't know yet how extensive the use of PRGs will be and whether that will reduce the use of IPRs in the future. And so I raise this point merely to say that we have some changes that are already kind of in the works that haven't gone fully into effect, and so we might not be at steady state yet with this system.
Thank you. Anybody else care to weigh in?
I think from talking to people, there's kind of two different opinions about IPR. One is, IPR is awesome. We are able to challenge patents that are weak, and we can get a settlement that's a fraction of what we used to have to pay for, a claim that we don't think is very strong. So, and that's going to be on the defendant side. And then I hear some litigators and more people who work with plaintiffs say, it hasn't changed really anything because now all that's happening is people are adapting. They're asserting more patents in every litigation because you can't file IPR in all of them. You're complicating things because even if you're giving an initial decision determination and you're also giving more data in terms of the court's outcome, if it's the PTAB's outcome, if the PTAB is not knocking out the patent, which would be a disposition that would be, in theory, earlier potentially than a court, you've just, made the parties not actually have more of a meeting of the minds. They're just going to sort of get more entrenched in their own position. The patentee saying, look, my patent withstood the PTO, let's settle now. And the challenger saying, well, no, I'm just going to, take another gamble at trial. Like, we're not going to, accord that any deference. And plus, there are other defenses we have. So I've heard, and what I thought was really interesting about Sean's data is that he showed that, again, in this very small selected tip of the iceberg, right, people who have patents that are both worthy of an IPR assertion and a court assertion, and I think it was almost also those who had gotten pretty far along with both of them, or wasn't sure what was represented. It was only filed in those two?
Only.
You were looking at the resolution
comparison
rates.
groups? Yeah,
Yeah,
so
you're looking
no.
at the time to resolution. But those, you had to get to a resolution, right?
So it's comparing, well, and it's ones that had a concurrent IPR, ones that did not. And then the
Okay.
third group was actually looking at earlier lawsuits, looking at time determination for earlier lawsuits before IPRs came online.
Okay, and I think you were cautious, but I wanted to ask you again, like, do you think of those two narratives, IPRs just made things more expensive and complicated versus IPRs really allowing us to get to a quick, cheaper way of getting to a merits-based resolution? Do you think your data conclusively points to one or the other, or do you think it's just too selected?
Yeah, no, I don't think I wouldn't want to conclude anything on that right now. No.
I think that's an open question, right?
Yeah.
You hear both stories.
I mean,
But I don't think IPR is going away, but I think that's the important question of, like, do we think IPR is a good thing, or it's gotten us, the efficient process that we think we want, or is it really just making things more expensive and complicated?
Yeah, I think the IPR, I think overall, it makes sense as a good development to remove bad patents. You don't want to do all of this ex ante. You can't expect probably the patent office to be able to catch it all. And it makes sense to have this review process after the fact. What strikes me, though, it seems to me kind of inefficient because you're allowing these multiple petitions. Like, what's the point of litigating the validity of the patent so many different times, right? Multiple petitioners can kind of come and challenge the same thing. You can have the same thing going on in federal court. I don't understand exactly what this redundancy buys us, and that's something which I really have never quite understood about the system. I don't know why it's there legally, but to me, it seems that is an easy way in order to improve the IPR process. Because the one thing is, if you have property rights and you don't know, property rights or pseudo property rights, whatever you want to think patents are, if you don't know whether they're going to be valid and there's no finality in it, that's hard for businesses to rely on this. You know, how are you going to know whether this patent actually protects your business? And ironically, it's going to be harder for firms that really actually need that underlying invention, for whom the patent is actually valuable. For the ones who are just sort of, you know, doing an arms race and getting patents for reasons that are more strategic, they maybe don't care. So you're actually hurting the ones that actually need the patent protection the most. And that, to me, seems potentially problematic.
So on IPRs, I think, you know, I also think that the basic idea makes sense. There are obviously some aspects of the design, particularly I think the interaction with ANDA litigation, which Congress probably didn't anticipate quite how it's worked out. That's going to require some tweaking or adjustment by Congress, hopefully sometime. I do think, related to this idea of expense, I do think it's disappointing that the IPRs have ended up being, I think, as expensive as they have been, although that's probably predictable when if you think through their substantive nature. But they haven't been a truly, extremely low-cost option. We're spending, typically people are spending, I think, $100,000 or more just in the early stage, relatively early stages of the IPR process. So it's not a truly cheap alternative to litigation, which can be frustrating for presumably some challengers, also for some patent holders who feel they're being dragged into this proceeding. Then potentially, if they do want to actually enforce their patent rights, of course, they're going to have to go back to district court. And so that's, it could be something where you do want to consider some other options, perhaps relating to David's remarks. If you had a patent holder who really wanted quick action and was willing to kind of give up some potential forms of remedies as a result, maybe you could have something like a small claims patent court. You'd have to get the defendant to also acquiesce to that as well, but in some cases, maybe a defendant, seeing how much they'll save on litigation costs, might accept that. Some co-authors and I have another proposal, which is to sort of layer on the front end of patent litigation a kind of quick look administrative review process, which could help both patentees as well as defendants by identifying some areas, say, where the patentee is most likely going to win, and there doesn't seem much of a case for the defendant. So there might be some alternatives to help add a kind of even cheaper front end or alternative path for patent dispute resolution.
I just will mention two ideas that I think are interesting to consider when we look at European opposition, which is more like PGR in terms of the time frame, but it's been in process. I think it's trusted and well understood. And I have a forthcoming paper with Christian Helmers and then Alfred Spigarelli, who used to be at the EPO, about how to sort of look at the European experience, both with respect to opposition as well as German nullification proceedings and what those can teach IPR, just because they've been around longer. And so two ideas that we came up with were, one, allowing patentees to amend their claims is something that is done routinely in opposition and allows the patentee just to keep a little more certainty and control over what happens in the post-grant proceeding. And it's paced well in Europe, and it's done, and it's, the parties seem to be okay with how it proceeds. So that's one thing to consider. The mechanics I'm sure are complicated and have to be executed correctly, but that's one thing to consider with respect to IPR. And another is consolidation of the suits. So kind of going back to Neil's point, it's a little different, obviously, because opposition is a 9-month window, so all the challenges come in at once, or they have to come in through that window, and then they get taken together. But if there's some incentives for those who might have, existing challenges, or instead of incentivize them to join a current IPR rather than to file their own in a serial manner, those are things to consider as well.
So I want to, in the interest of time, switch gears just a bit and go back to Colleen's presentation, which touched a little bit on the recent changes we've seen in complaint length. And I'd be curious to hear if there are other ways that the amendment of Form 18 have influenced litigation behavior, and whether there are other procedural changes, such as the amendments to discovery rules, that have had an effect. Colleen, do you have any?
Oh, yeah. So I haven't been able to look into discovery changes as such. Again, I think the bigger question from a quality perspective is, and that's something we didn't just do to run out of time, is we were looking at whether or not having the complaint data be more robust in terms of having a claim chart, whether that led to a faster merits-based resolution as well. So the parties might have settled faster, or the resolution rate was more, there was more meeting of the minds. Because again, the kind of dynamic you hear is like they put this vague patent complaint out. I have no idea what it's involved, so we have to go through back and forth. And there's a lot of kind of non-communication that then culminates in a lot of extra expense. But if you have the claim charts up front, it's not clear to me of whether it just makes it shorter or it actually makes it more efficient, because you have, like ITC, for example, where you get clarity much more quickly, but it's still quite expensive. So I think the overall question for me on the complaint side, maybe on the discovery side as well, is again, does the quality translate into a cheaper merits-based resolution? And to me, that's the right metric.
Right. I mean, I'll comment, maybe this is getting ahead to what I was partly going to say later in relation to octane fitness and attorney fees, but some of the changes that Colleen is seeing could also reflect the move toward a somewhat more robust, although still exceptional on its face, attorney fee shifting system, because certainly certain attorneys, looking through cases, have gotten the impression that courts are more likely to shift fees against you, require you to pay the other party's fees if it looks like you didn't have your case kind of together up front and you're presenting new theories later on. Whereas if you do have something more in the nature of what Colleen is describing, with your claim charts in order, specification of the products you're looking after, going after a description of them, then my guess is many attorneys will feel the perception is you're less likely to have that kind of sanction or remedy at the end of the day. So this is another example of a situation where you have reforms going, to partly David's point, reforms going along different tracks, and it can make it a little difficult to disentangle whether a particular effect is reflecting one reform or some combination of them, and to what extent which of the reforms has been most influential.
So to chime in a little bit on this Form 18 complaint change, and let me actually just kind of, to keep it all in perspective before I tell you what the comment is, I think that Form 18 is not a big deal, especially relative to like IPRs, which I think are a big deal, and I think Alice in many fields is a really big deal. I think that Form 18 is just not going to be of the same order of magnitude. The thing that I've heard, and I've heard this from a federal judge, is that she now sees a lot more motions to dismiss and complaints about the pleadings that she didn't see before in patent cases, and she sees these in other areas of law. She just used to not see them in patent cases. Now she sees them in patent cases. And these require, amendments that just kind of add more detail. None of that's really related to the merits of the case. So it adds more money. It makes patent litigation more expensive, but it doesn't get quicker. At least it doesn't seem to get quicker at the underlying, resolution of the validity issues or the infringement issues.
Great. Well, perhaps we'll actually build on some of John's comments, which are regarding fee shifting and, in particular, the octane fitness decision. My next question is, what has been the impact of octane fitness in practice? And I guess more broadly, do you have any views on the merits of a shift to a loser pays approach in the U.S.? Perhaps, John, you might want to follow up on that.
Okay. So I have to say I haven't, compiled data on this myself, but, looking at kind of data compiled by others, including partly some of the data presented by Colleen earlier, we do have some evidence that the octane fitness decision, which moved us away from the prior Federal Circuit quite structured approach to when attorney fees would shift to a more open, although on its face still limited, exceptional circumstances approach. This shift has resulted, as you might expect, in sort of some more success in motions for fees, and particularly in motions by successful defendants who have been defending against charges of patent infringement. And as I indicated in my earlier remarks, it's possible that this change is also correlated with some of what, well, it should be probably correlated. It might actually help explain some of what Colleen is seeing in terms of the greater preparation being put up front into litigation, whereas when I was in practice many years ago, of course, you were preparing up front because you were worried maybe about a Rule 11 motion, and now maybe an additional thing attorneys are thinking of, well, if we don't prepare as much up front, there may be a greater likelihood of attorney fees being awarded against our client. So now what's most difficult perhaps to disentangle from the data we've seen so far is to what extent has this attorney fee shifting actually discouraged some weaker suits? Because it's going back to David's remarks and mine to some degree, we've seen so many changes, it's hard to tell. And so many changes within a short period of time, it can be hard to tell which has been most has contributed to this decline, particularly when you have some other changes like Alice or whatnot on subject matter eligibility that seem likely to have had a very substantial role in declines. Okay, then going to the second part of John's question, should we go further? Well, this is something we've seen people push for a long time and push far outside of patent law. It's been a favorite of tort reform proponents in this country for many years to argue that we should move to a more European-style rule with regard to attorney fees, where you could have a general rule that at least some of the fees are going to be shifted in every case and have a basic loser pays principle in place. Many theoretical studies have suggested that would tend to promote higher quality litigation. It's commonly been resisted in this country because of a concern that it really raises very substantially the risk for many plaintiffs who may be pursuing sort of meritorious and, in other areas of litigation like civil rights litigation, may be somewhat new forms of arguments, trying to push the envelope. So in this context, we might not be so concerned about people pushing the envelope, but we might be concerned about patent holders who are relatively less well capitalized and are risk averse. And I recall, it's now probably about a decade ago or so, but once I was trying to look into sort of patent litigation insurance, and I was thinking of like patent litigation insurance for defendants. So I started doing these searches for this. I found what I thought was going to be a great European report on patent litigation insurance. And it was actually about patent litigation insurance for plaintiffs, because there was actually a concern that they weren't getting enough patent assertion by people who had meritorious patent claims because they were scared about the prospect of having to pay the attorney fees for the other side. And so that's a potential warning about one of the dangers of making a very large shift to a true loser pays system, and is one reason I myself have tended to feel more comfortable with incremental change in this area.
So just one small point. I think a lot of the changes that we're talking about might sort of interrelate with one another, right? So I kind of view octane fitness as kind of a delegation of authority to district court judges. Essentially, instead of saying you have this rigid test, you have more sort of ability to award attorneys' fees, to shift fees when appropriate. And you have to think about that as compared, bringing back to TC Heartland, right? So to the extent that which now it's, pre-TC Heartland, you actually could kind of know which judge you're going to get depending on where you file. I think Greg Riley and Jonas Anderson and others have really written about this. And that kind of makes it, to the extent judges have predictable practices in terms of how they would be likely to award attorneys' fees, then the octane fitness in that realm would be very different than in the realm now that we have, where it's not as clear which judge, there's not going to be as much of a concentration of patent suits in one particular court or another. And so the unpredictability of that, I think, it magnifies, in a way, the effect of octane fitness. So I think it's important to think about all of these developments as they relate together. It's also important when we're doing empirical analysis, because what we think we're measuring the effect of one event is really actually many times building on a lot of interrelated events that are occurring, approximately contemporaneously.
To build upon like the complexity of patent litigation, when I think of the days before octane fitness, the kind of perception was that the main or primary way that an accused infringer could recover its attorney's fees was via proving that there had been inequitable conduct in obtaining the patent. And so that put a lot of pressure on accused infringers to assert and allege inequitable conduct, so much so that the Federal Circuit said a few times that it was a plague on the system, and then that spilled over into prosecution practice. And I think that the octane fitness rule, which seems sensible to me, that if a judge who knows something about patent cases thinks it's like far out of the ordinary or out of the ordinary, that seems like a candidate for fee shifting. That seems like a sensible rule. We don't have as much pressure on inequitable conduct. If it's really weak on the merits on infringement or on validity, then that seems like a candidate for fee shifting. And so there's maybe a relationship between, changes in doctrine on fee shifting and other litigation defenses.
Great. Well, looking at the time, I think we've just got about enough time to have everybody provide a brief closing statement. I'd ask if you speak for probably 2 or 3 minutes, and we'll just go down the line. So we'll start with Sean. Thank you.
Thank you. Thanks again for having me, John and Elizabeth and Susan. So I really liked Dave's his metaphor of maybe too many cooks in the kitchen with patent reform over the last 8 years. And I think, so a lot of my research for the last 8-10 years really has been looking at patent trolls and software patents. And I think we had issues with software patents, that we had these uncertain property boundaries, providing opportunity for people to claim more than they had actually invented. And I do think there have been issues with patent assertion entities, taking advantage of the cost of litigations in order to gain nuisance value settlements and these things. Awful lot of these changes that we've had the last 8 years have been targeted directly towards these types of patents and these types of plaintiffs. And so I think I agree with all my co-panelists. I think that the idea that a lot of these things are going to be interacting with each other, a lot of these changes. And I think at this point, we really, we do want to see how things play out for a little bit, and see if there haven't been unintended consequences that have severely impacted maybe good patents and the types of assertions that we actually want to encourage. And then I think, part of what we need to do is those up here, and then also the FTC hopefully help with additional, research efforts to try to really tease the hard problem of teasing out impacts of individual reforms on some of these metrics, like who's able to sue and outcomes. So I think a lot of these changes have been positive, and looking forward to studying whether or not I'm wrong about that in the coming years.
I think I'm probably a lot more sanguine about the impact of the reforms. The reforms were targeted at dealing with abusive patent litigation, and I think by a lot of metrics that we didn't talk about, I think there's been a success. So if I consider an article I wrote in Patently about patent assertion entities by the numbers, it was a question of how many public companies, how many public PAEs are there, public companies. If you look at how those companies are doing, like there are a lot fewer of them. They may mostly be no longer that being an important business model as it had been. I went back to a number of venture capitalists that I had talked to before who were really upset about the patent system and really felt like it needed drastic reform at the time. And they've said, no, our companies are much more able to deal with issues that come up, and we don't see sort of the negative challenges that we had dealt with before on acquisition, with having to change business models. I still actually am hearing from some folks who are getting sort of the very meritless, or they consider themselves, right, these are people who are users of technology. I'm still getting calls from people who are getting hit with suits. So it's not to say that that behavior does not exist, but it's a much smaller footprint, I think, on our innovation ecosystem. And I frankly think those assertions were really giving the patent system a very bad name nationally, and there's just not as much attention paid to the patent system. And I think the attention before was negative attention, so I think that's a good thing. Now, again, still dealing with and calibrating the changes that have happened to ensure that we're striking the right balance remains a challenge, and we have to continue to use different levers. What I think is really interesting about the Form 18 findings, which really surprised me, that there was so much more use of claim charts, much more detail. I disagree with David that those are minor, even though they don't make headlines. They are increasing the quality of what is being discussed at the front end. Again, it's a lot of stuff you cannot see, that there's more certainty, there's less risk to companies because they have a sense of what they're dealing with early on. I think that's hugely important as it goes across the entire system and not just looking at IPR. Most of the litigations do not have a parallel IPR. They just happen day to day. There are challenges that companies bring, and they fight it out. And so that's an impact across the system. And so I think that these are positive changes, and that they need to be, again, we need to think about IPR and how to kind of calibrate and deal with it. But overall, I would say that if the problem was really dealing with patent reform was really targeted at abusive litigation, that there has been a positive reform. Now, the one thing I will say at the end is that, we think about what Congress and what the courts do. Where there has been, I think, what we've talked about today on this panel, there has been a lot of significant impact from sort of design decisions. So little changes or little sort of implementation decisions that the PTO has made. They've done a great job of coordinating with district courts so that district courts will stay the litigation and we don't have duplicative IPR and district court. In most cases, we have stays happening. That's not the case in Germany, for example, where if you have a nullification, the court still does its thing. You have two cases going on full bore. Often you'll have an invalid but infringed finding at the end of the day because the injunction is issued before the patent is even litigated. We have a more coordinated system here. That's a good thing, and that's a decision, and that's an implementation. That's an outcome that comes from good implementation. Same thing with Form 18. It seems like a trivial change, but in my mind, it's improved the quality of patent litigation across the board. It didn't take Congress to do that. It didn't take the Supreme Court to do it. It's administrative actors taking sensible steps. And so again, I think these design choices can have a big impact, and potentially bigger than those of the High Court.
Okay. So, yeah, I mean, I think, I may not be as enthusiastic as Colleen about the changes, but I think we hadn't seen a number of sensible changes and tweaks to the system. I remember once presenting a paper to my faculty at the University of Texas, and one of my colleagues, when he was hearing about the percentage of cases being brought in the Eastern District of Texas, and before just a single judge, Judge Gilstrap, was like, well, clearly there's something wrong with this. I mean, you don't really need to know anything more about this. There have been certainly some idiosyncratic aspects of the way the system was working, and bad practices, which a number of these reforms have helped address. I do feel that there are fundamental aspects of the system that it doesn't seem these reforms are addressing, and that are problematic, or at least present great challenges for the system, are going to be great challenges for the system over the next few decades. One is just the interaction between the numerosity of patents and patent applications, of issued patents and patent applications, in combination with the limited resources that almost all the relevant actors have to deal with, whether it's the PTO whether it's sort of private parties looking to try to obtain a valuable patent and be able to enforce their patent rights, or a potential or alleged infringers, or people who may be worried about being alleged infringers who have difficulties sort of navigating the sea of patents in a way that gives them a security and a feeling that they've achieved patent clearance. So it's not clear that the sum of these changes is helping really to address that sort of fundamental challenge which is going to remain with the system over the next couple of decades. And then still there's, as I said, sort of high litigation costs, and the fact that IPRs, although I think they have been a very positive reform from my perspective for the system overall, although they've had negative impacts for some players, have ended up being somewhat more costly than we might have hoped. And what can we do still to try to make litigation sort of less expensive, so that we can reduce the incentive for abusive use of those costs by patent holders, and at the same time allow, to the extent we think the patent system is serving any good, patent holders who do have valid patents that are being infringed, more effective access to the courts.
So thanks again to Suzanne and Elizabeth and John for the invitation. I want to talk just really briefly about predictability. Companies and lawyers value predictability in the patent system, and while bad rules can be problematic, there's also just a cost in switching rules, especially if it's done frequently. Unpredictability makes it harder for lawyers to advise clients on the proper course of action. It makes it harder for companies to plan ahead in terms of their long-term plans, such as commitments to R&D. And so I place a high premium on predictability in the patent system, and for that reason, as well as the point I raised at the beginning about the maybe too many cooks in the kitchen, I just suggest some caution among the institutional actors before making more large-scale changes to the system. The patent system's complicated, and I'm not sure if it's yet at equilibrium or steady state.
So it's convenient that my notes here say stability and predictability is what I wanted to talk about, and we only have a minute left here. I think that the issue of patent assertion entities, right, I think it's sort of a flashy issue. It's gotten a lot of press. I think it's going to fade. I think it already is fading over time. I don't think it's going to be as much of an issue going forward. I think the changes that we've talked about here are going to, it might be a death by 1,000 paper cuts, but I think it's going to become less salient over time. I'm echoing what Dave says here, because I think stability and predictability is something which I don't think is really improved over this time period. And a lot of it relates to something we haven't really talked about much, which is patentable subject matter. I think it's Allison, Mayo, you can decide whether something's going to be patentable or not, but it seems kind of crazy to me that one day something is patentable, the next day it's not, the next day it might be, right? So it seems to me if there's going to be stability and predictability, we need to kind of come up with a rule, whatever that rule might be. And in order to get I wouldn't even say right, just get a rule that's sort of clear and sort of stays stable, it might be necessary for Congress to step in to do this, because it seems like right now that issue is just bouncing around so much that it's very hard for businesses to plan and figure out what to do.
Great. Well, thank you. I'd like to thank all of our panelists, as well as their colleagues that joined them today. And if you would join me in doing so, and then we'll take a break and return after lunch at 1:30.
It's fun.